Evan Brown. I'm an attorney at Hinshaw and Culbertson, and I've been practicing law for about 10 years now, and I've been with Hinshaw since 2006, so about 4 years. And most of that time that I've been practicing law, I've focused on technology and intellectual property issues, and these days especially, that's really my practice focus is on technology matters. So I deal a lot with copyright, a lot with trademarks. Social media presents a lot of issues as well. Most of my clients, if they're not doing business directly online, and mainly what I mean is if they're not a technology company doing technology, they're of course involved with the web, either promoting their goods or services or communicating with the public or using technology in an integral way in some shape or form. Okay. So that's what I do in a nutshell, at a very general level. I am a blogger. I write a blog at internetcases.com, and as its name would suggest, I track developments involving the law and the internet, mostly new cases, interesting cases that come down involving internet law. So there's a lot of copyright matters, a lot of copyright issues, issues involving social media, privacy, branding, trademarks, domain name issues as well. So my blog is kind of my social media home, so to speak, and everything radiates out from there. I'm on Twitter at Internet Cases, and so I will post links to interesting stories about law and technology. I'll make some personal observations on there as well. Also, I am a co-host of the weekly podcast. It's called This Week in Law. I'm a co-host with Denise Howell on that. I really enjoy doing that because we discuss for an hour or so every Friday what's gone on that week in terms of law and technology.
So tell me about what are some of the issues that your clients are facing right now with social media? Mm-hmm. What are they asking you about, and how are you advising them?
A big issue in stating it, in a general way, is reputation, and that can mean a couple of different things. People go online now to communicate and share their thoughts. It's so easy to express your sentiments on something because there are so many tools that allow you to do that, whether it be a social networking platform like Facebook or a platform like Twitter or blogging. I mean, I consider blogging a form of social media as well. So it's very easy of course, for people to go online and share their feelings and their sentiments and their opinions about services they may have gotten or goods they may have purchased or experiences they've had with someone providing those things. So a big problem, a big issue is how to handle negative commentary about a company's goods and services online. So it involves looking at what exactly is being said, whether it's something that may be actionable under the law. Is it defamatory? Is it trademark infringement? Is it something like that? Examining that and looking at the overall context to see how action against that type of conduct would be perceived in the marketplace. There's a term that I love to talk about, and I wish I had been bright enough to coin it. I did not. I think it originates with a guy named Mike Masnick out in California who writes a widely read blog called Tech Dirt. But the term is called the Streisand effect. I'm sure you've heard about it. And this is something that I advise my clients to consider very early in the game when thinking about what kind of action you can take about somebody who may be subjecting them to rough treatment online, saying something bad. Long story short, back in I think it was 2003 or 2004, there was one of the universities in California wanted to fly up and down the coast of California taking photos of the coastline. And Barbra Streisand has a home in Malibu there on the coast of California. And she objected to this project and filed suit. I don't know the disposition of the lawsuit, but that's not really the point of the story. When she filed suit under some state law in California, I think it was some kind of invasion of privacy, it may have even been like an anti-paparazzi law, that drew attention to this fact that she objected to that. And the irony of the story and the paradox of it is that nobody really knew Barbra Streisand had a home there until she complained about her privacy being invaded. It just made it much worse. Right. Drawing attention to the fact that she was taking legal action. And that's something that's very important for For individuals, if they're a defamation plaintiff or if they're a company who is trying to silence an online critic about their goods or services, that's something that's very important to think about, whether you're going to be blowing the dispute out of proportion and raising its profile, bringing more attention to that which you want to silence in the first place. So that's a huge issue, something that I see across the board, regardless of industry, and it's something that has some very interesting psychological and sociological aspects to it as well, not only the legal ones. So that's a big one. A very common fact pattern that I see is somebody has set up a bogus profile on a social networking site. It seems like it's still MySpace. all this stuff happens on MySpace. Occasionally you'll see bogus Facebook profiles, but even though MySpace has declined in popularity, that's where you see the bogus profiles of for example, the school principal or something like that. The social networking sites the intermediaries in general want to do the right thing most of the time, and content that is harassing but not defamatory, but can tend to hurt someone's feelings, is usually can usually be construed as a violation of that intermediary's terms of service, and they want to do the right thing and make sure that people are compliant. So a lot of times it's very effective to send a letter to the intermediary, whether it be the social networking site or platform like Yelp or something like that, and just ask them to take it down. Look, this is a violation of your terms of service. This person is impersonating someone else. This information is not helpful to anyone. It's diluting the power of your site and the usefulness of your site. Why don't you please take it down? And many times they will. That's one strategy. But parties in the position of Yelp can be bold when it comes to the decision of whether to take content down. And since we're having this conversation, I would be remiss if I didn't mention the robust immunity that a service provider like Yelp enjoys under the Communications Decency Act. Title 47, Section 230, which is part of the Communications Decency Act, says that no provider of a service, of an interactive computer service, can be treated as the publisher or speaker of any content that's provided by a third party. So a number of companies have relied on this robust immunity. I mean, going all the way back to the late 90s, there was litigation involving AOL and allegedly defamatory postings to a forum. The first and still kind of the leading case on this is a case called Zeran from the Fourth Circuit. Companies like eBay have enjoyed the immunity for negative content that people have posted. Craigslist, here close to home, was sued by the sheriff of Cook County, and the court, relied in part on Section 230, getting rid of the case because Craigslist, should not be, the court held not be treated as the publisher or speaker of that content. That is a deviation in the law from the common law principles that had developed for ordinary brick and mortar publishers over the course of all those years. If a bookstore had notice of the fact that, if a bookstore has notice, it's still this way now, but traditionally, if a bookstore has noticed that there is content on its shelves that is defamatory, it has a duty to remove that off of the shelves, and if to the extent that it does not, the defamed plaintiff can go after the bookstore, and the bookstore can be held liable. That's different in the case of an intermediary on the web who may do something very akin to a bookstore like Amazon. Even if they know that there's defamatory content there, there's no duty, even if they're put on notice of it, to take that off. So Yelp, going back to our example here, if a restaurant owner, for example, feels that a review that somebody has left is defamatory, saying, we actually do cook the food here. We don't serve it raw. That would be something that would be defamatory if false. They're not going to have much luck going after Yelp and filing a defamation action for them because of this immunity that we're talking about.
Fantastic.
Great. Thank you, Dan.
Thank you very much.
All right.